Okay, good evening, everyone. This will be the second run of our QS series, the latest in the QS series from Connor. Tonight, he's going to be talking about variations. So, as always, if you've got any questions, put them in the chat box to me, and then at the end, I'll pop them in front of Connor, and he'll get you the answers to them. If you've got any more in-depth questions or want to speak to him about a specific issue, his contact details are on the slides, are on the website. Please feel free to email him or contact him with any specifics that you'd like an answer to. We will also be releasing shortly our June online seminar dates, so keep an eye out for those. Those of you that aren't signed up for the newsletter, let me know, and I'll pop you on the distribution list, and we can make sure that you catch details of everything that's coming up. Right, without further ado, Connor, over to you. Stun and amaze us about variations, please.
I'll try. Thanks, Julie. Good evening, everyone. You're all very welcome to the latest edition of what we call the QS series. This evening, we're going to look at variations. Yeah, just a bit of QS series. Just I'm building on some experience that I gained during my time as a QS, and also just introducing more and more of the more and more law, as during my time as a trainee solicitor. So look, I hope that it'll give you a bit more background into how the courts interpret a lot of variations and contracts, and it'll all just take some tips away from it that will that'll help you have more success in your variations when you come across them on site. Yeah, just before we begin, just a bit of housekeeping. So yeah, look, if you have any questions, just put them in the chat box, as Julie said, and we'll answer them at the end. Also, just to note, this is more educational and learning, and rather than legal advice. So look, if no problem if you do need legal advice, or if you have any specific issue, don't be afraid to get in touch. Okay. Right, so the agenda this evening, we're going to start off a bit of background and, what definition about what variations are, which is straightforward. Then we're going to look at what does the contract say. So this is basically look at the interpretation of the contract, look at what we need to include in a contract to make sure that when we are carrying out the work that, it says what we want to say in order to get our variations. So very important area to understand. Then we move on to categories of variations. We've got two main ones, and we're going to deal with those. Then also look at the valuation rules and how the courts interpret those. Then finally we'll just wrap up with some I suppose just some presentation tips. What would you expect? Just based on some experience. What I used to include for variations, which look, you're probably all doing it anyway, but there's no harm just to have a refresh there before we finally conclude things this evening. Okay, so just a bit of background. I mean, you'd say, why do we have variation clauses in contracts? I mean, employers certainly don't want them because they don't want to be paying any more for, what you're contractually obliged to do. But, they are necessary. So, what they do is they give us, they allow us to make changes to the works without voiding the contract. Gives the employer the power to order varied work or additional work. It ensures the contractor is entitled to be paid for additional work, ensures the contract is not frustrated if it becomes impossible to carry out the work, and it also sets out the rules for valuation of variations and avoids what these quantum mirror type arguments that you don't see as much of them anymore, because the contracts are quite broad and deal with most issues that are foreseeable, but you do get them every now and again, this quantum merit. So like fair payment, which generally means cost plus, which obviously employers are going to want to avoid, and to be fair, contractors don't want to end up there either, because it can end up in quite long and protracted talks and discussions about variations. So yeah, so that's the kind of background to variations. Definition. We know what variations are. They mean a change to the contract works, which is usually instructed by the architect, contract administrator, or employer. This evening we're going to focus on variations under the contract, and so by that I mean Section 5 of the JCT contract, if you're familiar with it, or in NEC, you'd be looking at Section 60, and the compensation events. So it's those areas that we're going to be looking at. I mean, what we can also have is variations to the contract. Best example I have of these is a deed of variation. That's where you have an existing contract, but you wish to vary it post-contract. So generally that's done by a deed of variation, where you want to draw a line in the sand for events that have gone on to date. So yeah, look, so this evening it's all about under the contract. So yeah, so we're going to go into what does the contract say. Now this is contract interpretation. So what we need to see is, does the contract clearly set out the common intention of the parties when the contract was formed? There's significant differences between standard form approaches. We have systems like design and build, remeasure, lump sum contracts. So all of those are all very different in their own, in what they say and in what the intention of the contract is. We covered that in quite a bit of detail in the interaction between quantity surveying and construction law. Check out the website for slides, and there's a recording on that also if you want more information there. So contract interpretation. So this is basically, this is how the courts interpret contracts now, and it's been developed from the case of Ahern versus Britain. So what the courts do is that they give the natural and ordinary meaning of the clause and the natural and ordinary meaning of the words in order to give effect to what the parties intended. They look at any other relevant provisions of the agreement or contract. They look at the overall purpose of the clause and the agreement. Ground number 4, they look at the facts and circumstances known or assumed by the parties at the time that the document was executed. Now that's a very important ground, especially when we're looking at construction contracts, and we're going to deal with some case law around that point, because the facts and circumstances known or assumed by the parties, it's very difficult to cover everything in our contract, but we'll see what happens when we don't. They also look at commercial common sense, which the English courts have done since contracts began, really. But what they want to do is they disregard any subjective evidence of the parties' intentions. So that's in order to, if you were to keep introducing subjective evidence, it would lead to uncertainty in the law, and the courts are very, very careful not to do that, because there would effectively be no kind of structure to how the courts interpret, and what that would lead to is conflicting decisions, and ultimately parties not knowing where the law was on any particular point. So the courts are very careful to avoid that, and what they're doing here is that they disregard the subjective evidence. So what they're saying is, if you want something in your contract, deal with it in the contract. If not, then you're going to, you may come to regret that at a later date. So a good way to to warn the parties. So general rule here is handwritten over typewritten over print. So this is like a bit of a mini hierarchy, effectively, is that if the parties really focus in on one particular area and have emails in handwritten means they've actually dealt with a point very specifically, well, that will take precedence over whatever's typewritten. Typewritten usually can be, as an example, would be a schedule of amendments. So if you deal with a very particular point, and as long as it's included in the contract, then it would take precedence over what we call the schedule of amendments, and the schedule of amendments will override a print. Print typically means in our area, it means the standard forms of contracts. So look, it's just a general rule there. Obviously, all of these things turn in their own specific facts, but that's the court being as helpful as it reasonably can to deal with contract interpretations that arise, that come before the courts. So yeah, that's some background as to court's view. So for proper interpretation, so most contracts, JCT includes a clause. Generally, it's clause 1.3, and it says that the document is to be read as a whole. So, and what that does is, this is a position which I think is generous to the contractor, because if a contractor includes his schedule of amendments as a contract document, then and that has been included in the contractor's price, then effect will be given to the schedule. And as we saw from the general rule, the schedule of amendments will have been, will be specific points in relation to the contract, and that will be given, preferential treatment. So the schedule of, clarifications will take effect. So that's a good position to be in. But you've got to make sure the schedule of clarifications is in there to begin with. Schedules like this generally included, they set out the contractor's intention, which contractors, and I've done this in my experience, you use the schedule of clarifications and assumptions, and that gives you the benefit that you can use it when you're proving your variations that arrive, during the course of the project. So yeah, so the schedule of clarification is very common document, but you want to make sure it's in there, and if the document is to be read as a whole, then you've got every chance that is going to apply and help you out with those variations. But what happens when you have a hierarchy clause? Now, hierarchy clause effectively reverses the position where the document is to be read as a whole. So this applies where the contract contains such a clause, and the interpretation has to be in accordance with that clause. So this is a position that benefits the employer, as it will work to ensure contract interpretation has the employer's requirements documents at the top of the hierarchy. The contractor schedule of amendments will be of low priority if in fact it has been included at all. I mean, I've never seen a hierarchy clause to put the contractor's schedule of clarifications in at the top. It just doesn't happen. And it'll always be the employer's requirements, the contract conditions that are in at the very top there. So if you have the hierarchy clause, be very careful with it. And because in the event of a conflict, so where you have a position set out in the contract conditions, I take the most common one being ground conditions. If you have that set out in the contract conditions, which it usually will be clarified in around clause 211, of a JCT contract, if there's a conflict and it's dealt with, then the contract will be construed in order of the hierarchy. So regardless of whether, even if you have the schedule of clarifications included, if you're working in line with the hierarchy, then the contract conditions will trump the schedule of clarification. So just be very careful with that. Very important to understand the structure of your contract when before you set out down that road, and be very careful when you're dealing with hierarchy clauses. Okay, so now we come to what if the contract is silent? So again, if it's silent, I mean, an early warning that the English court sent in this case, was 150 years ago. This was Thorne versus the mayor and Mayor of London, effectively. They were building Blackfriars Bridge, and the contractor provided a lump sum to build it. The method of construction was described by the employer in the contract, but it turned out that method of construction was actually unsuitable. And in that case, the contractor was not granted relief because the court said that he should have foreseen that that method was unsuitable, and he's not going to be given any relief. So very harsh position, but they lay down a marker then, and this remains, if you're dealing with lump sums, especially, this remains a position in English law, and serves as it served as an early reminder to contractors to clarify the risk of these events in their contract. So that's the lesson there. And so, if the contract is silent, so we'll frequently end up in a position where we're looking at the reasonable or experienced contractor test, which is very common in ICE or, NEC and FIDIC forms, which brings in, what was reasonably perceivable by the contractor at the time of contract. Now, there are some examples where variations were approved. They're rare because, because the courts do expect the contractors, they're specialists, they should be able to deal with this, and they're not going to get off the hook if they effectively make a bad bargain. So that's the message. So some examples where variations were successful. We have the case of Barton versus Stiff. In this case, we had a high presence of salt water that penetrated brickwork, which had to be redone. That was a very, very unusual case where the salt water actually eroded say the cement in the it reacted with the cement in the brickwork mortar, and effectively the a significant amount of works had to be redone as a result. But what the court said was, look, that's very unusual for that to happen, and so they said it was not reasonably foreseeable, and the contractor was entitled to a variation in those circumstances. We also had the case of Bacall versus Northampton Development. Now, in this case, the employer gave an implied warranty in the contract that the ground was a mixture of sand and clay. And, when the ground turned out to be different, the contractor was entitled to a variation. The key point there was that there was an implied warranty that the ground was in a certain way. And if you do that, if employers do that, then they do leave the door open for contractors to get the variations. But, most contracts now say that the employer does not warrant the information provided provided to the contractor at the time of contract as a result of this case. And that's not that position is not going to change, is very unlikely to change anytime soon. Okay, continuing on with if the contract is silent, well then, continuing the reasonable and experienced contractor test, we've got many cases where, variations have not been approved. I mean, as you can imagine, this is often these are often cases that end up going all the way to, end up in the technology and construction court, can even end up court, sometimes even Court of Appeal. I mean, there's an awful lot of case law around this point, and more often than not, the variations are not successful. So the first case here is Van Oord versus Allseas, and in that case, the site investigations were limited. The areas not tested, which, unsurprisingly, turned out to be significantly different to those tested. I mean, that's very common that that happens. But again, here, what the court said was that the experienced contractor should have foreseen this. So, the courts had little sympathy for the contractor. He should have made he should have made allowance in his bid for different conditions, or at least, being specific about, what type of ground conditions he expected, or what type of ground conditions his price was based on. If he had done that, he would have had a better opportunity, but he didn't. The contract was silent. He should have foreseen it, and no variation. The next case is Obrascon versus Gibraltar. Now here, the site had previously been used for military activities. That was made clear by the employer in basically the pricing document provided to the contractor. But the contractor did not address the position on contamination in the contract. So, you have military activities, there's likely to be contamination as a result. So, and the courts went along with that and said it was reasonably foreseeable that the contractor should have dealt with the contamination in the contract. So, again, you can see the courts are, if you've made a bad bargain, if something doesn't work out in your favor, you haven't dealt with it in the contract, it's, you're not going to get off the hook, or you're not going to get any sympathy. So just bear that in mind. It's very important what is in the contract in order to get our variations, and a massive part of interpretation of variations. Other key considerations when you're looking at the interpretation is entire agreement clauses. Be very careful with these, because often there's a lot of correspondence pre-contract dealing with points that actually can arise during the course of the contract. So if you've actually stated what your assumptions were in an email, and subsequently that email is not included in the contract, if you have an entire agreement clause, you can't rely on that contract, or on that email. So, a harsh position, but understand the makeup of your contract, because an entire agreement clause will mean that that email is not admissible, and you can't rely on it. And if you can't rely on it, then and it's not dealt with in the contract, then you're going to struggle to get your variation. The next point is the understanding the employer's requirements and the contractor's proposals. I mean, this is it. Often we actually see now that the employer's requirements effectively become the contractor's proposals. I mean, that's effectively the position that happens in design and build contracts now, anyway. So basically, what they're saying is that we've told you we told you what we want this building to look like once it's complete. You've given us a price. We've agreed a contract. Please go away and give me that building. I mean, it's going to be quite difficult for you to come back and get any variations out of me at a later date. So, you know, employers require ERs and CPs, as we call them, very important to understand those, especially when you're looking to, you know, to recover variations at a later date. Conditions precedent and the requirement for notice within a period of time, as with NEC. So look, obviously, you know, if you have conditions precedent in your contract, then if you got to give the notice. If you don't, you know, case law, the courts tell us that, you know, you can be in a position where you're not entitled to anything. You'd have to you've carried out the variation, but you won't be entitled to any reimbursement under the contract if you fail to give your notice. So very important point. So always bear that in mind as well. And finally, notice. So this one has been popping up, this no oral modification. So if you have a no oral modification clause, which was the case in this case of Rock Advertising versus MWB, a no oral modification means that you can't modify the contract orally. So that means that would include variations. So that means no variations can be instructed orally. So if you carry out a variation and you haven't been instructed in writing, well then technically you may not be entitled to payment as a result. So again, just if you see those clauses, understand them and use that as a reason to say that, you know, to keep your policy that we don't carry out any variations unless they're in writing. I mean, I know a lot of contractors can operate that way anyway, which is good because it provides a track record of what's been agreed. But especially if you've no oral modification clause, be very alive to that position. Okay, so we're just going to conclude on the contract interpretation area. So, you know, my first point, and this has been, you know, these points are basically on, you know, my own experience as a QS. So what we're saying is that most variations are written into the contract before the QS receives it. So hence why the interpretation and the structure is very, very important. Key the structure. Where does the schedule of clarification sit? I mean, I used to love schedule of clarifications because, you know, they were always good to have in there. They'd really clarify a position, you know, that you've assumed that you've based your price on, and you know, you always knew that there was likely to be changes, which set you up nicely for the variations at a later date. I mean, you know, as a QS, that, you know, that was part of the remit. I mean, we wanted variations because often you can make, you know, we all know in construction contracts, margins are tight, so variations can often be a good way to you know, to increase those margins, you know, and so schedule clarifications vitally important. You know, variations, you know, one of the key reasons why contracts do not get executed. I say that because, you know, often you know, grounds that are unclear can become the stumbling blocks to signing a contract. And I remember, you know, in practice, this used to always happen around ground conditions. And as we know, you know, a lot of these contracts, you know, can get agreed whilst the works have actually started. So you might be on site under a letter of intent. But, you know, the main one that used to pop up was, yeah, as I said, was ground conditions. And, you know, often you could be into the project 4 or 6 weeks. You know, the very point on ground conditions you could be discussing might actually have materialized at that point. And neither party is going to want to give away their rights to defend or bring a variation. And all of a sudden you're in a position that you will not have any formally executed contract. So that's been on my experience, that the variations and ground conditions especially, I've had, you know, so much experience with ground conditions that you know, that's the key reason why the contract doesn't get executed. Doesn't mean you don't have a contract. It just means that the position on the risk, and especially ground conditions, is unclear. And what happens is that you end up in a battle of the forms, which again have complex and difficult arguments to resolve. So should be avoided at all costs, as much as possible, because, you know, you're into a situation where you know, who fired the last shot effectively, you know, who sent the last email, who dealt with the point last, you know, often that will, you know, that will be the winning shot. But, you know, that's quite a general synopsis on the ballot of forms. Always bears down on the facts, and you always be very careful to avoid those type of arguments. Very complex, very difficult, and yeah, you just don't want to go there. So get it clear and get it wrapped up in the contract. Okay, so we're going to move from contract interpretation. So we're going to move to what I call categories of variations. So two main categories. Now, again, the language here is very much in line with JCT. Most, you know, from feedback that I've received on other webinars, you know, most of the contracts tend to be JCT. So, you know, we try and follow that line just so we want people to understand what the contracts say, and you know, if you can appreciate the principle, you can adopt the same type. I mean, you know, NEC, FIDIC, they're written in similar styles. They've all got some nuances, but if you can appreciate the principle and take that away, you can apply it at a later date to those other contracts as well. So we're looking here at the alteration or modification of the design, the quality or quantity of the works, which will include the addition, omission, or substitution of any work, the alteration of the kind of standard of the materials, which is generally quite straightforward because that usually comes back to the specification. So if you have a contract specification, and you know the construction specification, you know, which comes out during the works and it's changed, well then straightforward variation like that point should be uncontroversial. And you also have the removal from site of any work. So obviously not any work that the contractor has not carried out in line with the contract, because you know he's not going to be entitled to additional money to remove work that he's built incorrectly. So it's only work that he may have carried out that the client might want to change. So it does allow for the removal there. But you know, we're going to focus on addition, omission, especially, you know, which pretty uncontroversial. You know, usually become a schedule. I just included in evaluations, but I mean, you just keep, you know, you just track it because you need to deal with the additions and omissions in order to get paid. And that tracks the changes essentially, you know, in the contract drawings, in the contractors, in the employer's requirements during the course of the contract. And then also you look at, it's just amending the quantities. You know, the rates largely remain the same unless the restrictions imposed are in line with category 2. So we're going to deal with one of the points I wanted to pick up on was omissions. Omissions can become controversial and they're subject to limits as established in Abbey Developments versus PP Brickwork. Now, in that case, Justice Humphrey Lloyd, he picked up on the point. He was saying that, you know, it's sensible. So like omission clauses are sensible. If the development no longer becomes viable, then omissions are sensible because, you know, the employer doesn't want to continue with the contract, and, you know, should be entitled to, you know, to omit works. I mean, you know, the point on, you know, loss of profit, loss of opportunity, etc., is separate, but, you know, to have the omission clause in there makes sense. But what he did want to clarify was where contract works are omitted so that they can be carried out at cheaper prices by other contractors, well, that is not permitted. And he confirmed this in the passage when he said that a contract for the execution of work confers on the contractor not only the duty to carry out the work, but the corresponding right to be able to complete the work which it contracted to carry out. To take away or to vary the work is an intrusion into and an infringement of that right and is a breach of contract. So, you know, be very alive to that. I mean, if you want to omit works, then, you know, it's a breach of contract if you do it and you give it to another contractor. That is not allowed. Again, we go back to the bad bargain points. You know, the courts are very clear that they won't reverse a bad bargain. If you made a bad bargain, you've let works at a price that is higher than what you possibly could have got, and you've contracted on that basis, well then tough. Okay, you're not going to be able to get away with it by omitting. So that's just that's a very important case when it comes to dealing with omissions. You know, when you come across them. Okay, so we're going to category 2. So category 2 variation, you know, is the imposition of an instruction of the architect or contract administrator of any obligations or restrictions in regard to access to the site or use of any part of it, limitations on working space, limitations on working hours, and the execution or completion of the work in any specific order. So again, very, frequently used JCT language. So we'll go through some of these. Access to the site. So again, this happens. I used to do a lot of work on, high-end residential basements in and around Kensington and Chelsea. Obviously, these sites are very restricted. Often you only have access in through one area of the site. So, I mean, obviously, if I suppose restrictions are imposed. I mean, one that I had experience of was where where you had a parking bay suspension at the front of the site. And basically in the contract documents, there was a suspension of 4 parking bays, but the employer during the works, he didn't want to keep the 4 suspended, so he actually reduced it to 2. But what he didn't realize was the impact that had on on deliveries to the site and our ability to get materials in, and that led to a drop off in productivity, and also additional delivery costs, because it was now taking longer as well as a result, because you had a longer reach into the site. So that was, in that case, you were entitled to a variation. I mean, it's those kind of circumstances where the restrictions come into the access that you got to be alive to, and variations will arise as a result of that. Working space, which involves, working in close proximity to, most commonly involves working in close proximity to other trades. But be careful of this. I mean, most contracts state that the contractor will not have exclusive use to the site for this reason. So if you have specific concerns, then, as we were saying earlier in the contract interpretation, deal with it there, because just saying that, a contractor was in my way and I lost productivity is not going to wash at a later date. So if you have concerns about working space restrictions, deal with it specifically, deal with it in the contract, because otherwise it's going to be very difficult for you to recover any additional costs. Working hours usually becomes an issue in relation to Saturday working or local council restrictions on delivery hours and noisy working hours. Again, in Kensington and Chelsea, it was often the case that they used to update their guidelines for people building these these resi basements. This now was, say, between 2010 to 2016, and you would have multiple basements being built on single roads, which did cause a lot of congestion, a lot of problems for residents. So they obviously wanted to clamp down on that, get rid of the Saturday working, also restrict delivery hours. And so they would say that you couldn't deliver to the site before 10 o'clock or after 4 o'clock was quite common. That's because you didn't, those are, what we call rush hours. And obviously, having construction traffic like, concrete wagons, muck-away lorries in the area is obviously just going to contribute to that. So restrictions like that. Also noisy working hours, they would say that, no noisy working, so noisy working, say, or they restrict it to between 10 o'clock and 2 o'clock, and 2 and 4. So, I mean, obviously, if it says that in the contract documents, then you're not going to have a variation. But obviously, if they make these changes during the course of the project and it wasn't, and it said something different in the contract documents, well, then you're going to have a variation. So you just got to be alive then to how you prove that, and we'll come on to records at a later point in this session. Another category 2 ground was to execute the works in any specific order. So I mean, it depends on the contract wording. If the contract is silent as to the order that the employer's team, if the contract is silent as to how the contractor intends to carry out the work, and the employer's team issues an instruction to complete it in a reasonable order, then this will not always amount to a variation. This is actually very applicable at the moment, because we're looking at different order or different ways of working as a result of the current COVID situation, because a lot of sites, as we know, are trying to, obviously keep going and maintain some progress, but numbers on site have dropped off. So, you know, if you've been asked, you know, most contractors are now being asked to work in a, you know, work in a different manner, work in a more restricted manner with less operatives, then, you know, you know, is it reasonable? So a key point to deal with there is going to be, is it reasonable for employers to do that? And this is going to, you know, this is an area that's going to become you know, a real hotbed for discussions over the next few months, when, you know, if it essentially, especially if productivity drops off, and, you know, contractors are working less productively but at similar costs, then losses will be incurred. So I can see this being a real hotbed of, you know, for future discussion on, especially in circumstances surrounding COVID. But then we also have, so moving on to the case here, which I've highlighted, just Neodox versus Swinton. So here we had a contractor who had a contract, but he hadn't specified how he was going to carry out the work. Now the engineer instructed the contractor to do it in a very specific way. And what the court said was that the contractor would be entitled to a variation if the engineer's instructions amounted to a breach of contract. And in this, but I mean, in this case, he said, yeah, if it's a breach of contract, then it's a variation. But he said in this case, the working method was reasonable, so it wasn't a variation. They went on to say that the instructions amounted to a variation of or in addition to the contract works for which the contractor was entitled to an extra charge under the contract. But effectively here, the contractor in the situation where the court said the engineer's specified way was reasonable, and as a result, you know, unless you can prove the loss, then you know, you won't automatically be entitled to variation. So again, you can see the court's position on the interpretation here. With category 2, I mean, especially in, you know, in JCT, do bear in mind that you have the reasonable, you know, the right to reasonably object. It only relates to category 2. I just put in example clause 3.5, and JCT allows you to do that. Typical examples include, say, work outside the contract. For example, asking a ground worker to carry out painting. I mean, you know, it's reasonable for the ground worker to say, you know, we're not interested in doing the painting. It's not within our remit, and it's not something that, you know, that we're special, that we essentially want to do. So, you know, that's a reasonable right. Also, if there's a change of access, I mean, we're looking at something significant. I mean, you know, you'd want to raise that early if they wanted to change the access. If you had a large, I mean, this is like large greenfield sites. I mean, and just make them aware, obviously, of the, you know, the impact that will have on the job. You want to specify, you know, what you've assumed that you hadn't allowed for it, and deal with it that way. Another ground would be where, you know, you've been given an instruction to provide a specific piece of kit, of equipment into the building, which may have a long lead-in time, for example. So, I mean, you know, it would be unreasonable if an employer, you know, found this out and wanted to instruct a contractor to provide that piece of equipment, which he knew was on a long lead-in time. It's only fair that the contractor could resist that, you know, pointing out the long lead-in time and the issues it's going to cause. And the contractor would be perfectly reasonable in acting that way in that situation. Lack of agreement on price is not a sufficient ground to object, and the fact that there is an error in the bill of quantities rate is not a reasonable ground for objection either. So do bear those in mind. I mean, as much as a lot of contractors would like that to be the case, it isn't, and so, you know, it's not worth raising the objection on those grounds if you do come across them. Okay, valuation rules. So where the execution of additional or substituted work is, you know, similar character, conditions, and quantity as the rates and prices in the bill, well, then you just keep going with the bill or the contract sum analysis. You know, that's fairly straightforward and uncontroversial. If the work is of a similar character, but there are different conditions and quantities, then a fair allowance must be made for that difference. So look, that really comes down to the different conditions, which we're going to come on to. Also, where the work is not similar to rates and prices, then the valuation must include, you know, you must price the work on a fair and reasonable basis, or on fair rates and prices. And we look at how the courts interpret that now as well. So we're going to look at similar character but different condition states that a fair allowance for the change in conditions must be made. So this was dealt with in the case of Henry Boot construction versus Alstom combined cycles. And what the court held that to mean was that a fair valuation generally means a valuation which will not give the contractor more than his actual costs reasonably and necessarily incurred, plus similar allowances for overheads and profit. For anything more would confer on him an additional margin for profit and would not be fair to the employer. So what he's saying, what the courts are saying is that, you know, the valuation must be fair on the contractor, so he's not getting paid more than he should, which would be unfair on the employer. So he's trying to find, and he's saying that you are entitled to your overhead and profit, which is, you know, reassuring that is. I mean, we assume that is the case, but it is nice to be able to rely on it as part of the case law also. You know, Weldon Plant versus the Commission for New Towns dealt with the same point. Instead of fair valuation to be made that excluded an allowance for overheads on the basis the contractor had to establish that it either incurred additional overhead or that it was denied overhead recovery. You know, that was unfair. I mean, if you should include overheads. The court held that a fair valuation had to include an element of account of profit also in the absence of special circumstances. So again, Weldon Plant following up on the position in Henry Boot versus Alstom. And if you want to know more about, you know, how the courts interpreting variation language, and there are two very good cases to go through if you're interested in that. Other key considerations in this area that come up quite frequently: what to do if you have an error in the bill or the contract sum analysis rate. And when I say this is where you make an instruction to carry out more work where there's an error. So yeah, you receive an instruction under the erroneous rate. And in the case of Henry Boot versus Alstom, they said that you still had to carry out the work in line with the contract rate. You know, that again, we go back to bad bargain. Courts say it's kind of like tough lads. That's the position. So deal with it effectively is what you're saying. So, you know, be alive to that if it does pop up. The next point, you know, just a position after PC or practical completion is that, you know, after PC, the architect and contract administrator are, you know, they're unable to instruct the contractor unless it's specifically provided for in the contract. The contractor should seek clear agreement before proceeding in order to ensure payment. So, you know, if you are after receiving your PC cert, then do be very careful as a contractor. You may find it difficult to get paid. If you do want to go ahead with it, obviously, just satisfy yourself that you're going to be fairly reimbursed for it, because you know the position is different when you are in those circumstances. So do be aware. Okay, we're going to move on to the last area. I mean, like we talk about variations, so just when we see people coming in with variations, and you're saying, "Oh, I'm not getting paid for this," you know, what we want, you know, the information that we want to see, and we always talk about records, you know, records when it comes to, like variations, loss and expense, when you're putting in your extensions of time, and you know, this is what we mean. I mean, I'll just give you some points. Look at, you know, they're well known, but you know, no harm as a refresh to deal with your, you know, daily diaries, your progress reports, your dropline programs, photographs, your emails, notices, allocation sheets, concrete pour sheets. You know, they're everything that we're looking for. I mean, look, there can be more in specifics, but you know, generally when we talk about records, and we have mentioned it a few times, and the courts want to see you having proven that you have incurred a loss, even if you are entitled to the variation. So, you know, these are the types of records that they will be wanting to see. So look, it's just here as another reminder that is what we'd be looking for. And just finally then, I mean, you know, this is the final point. And when you're presenting them, you know, you want your narrative which explains the change that occurred, and and how that affected your contract intent. So you can see the importance. So this kind of brings in the, the contract interpretation again. What you don't, if you're looking for variations, you don't want to have been silent on the point. Because you want, and it always makes it a lot easier for your narrative when you can cite, an express term in the contract to say, well, that was what I assumed I would be doing, or that's what I thought I would be doing. You instructed me to do something different, and that is the reason for the change. So just really kind of reinforcing the point, to, don't be silent in the contract, understand what's in there, and then the narrative and the variation will just flow from that and make it a lot easier for you to recover that entitlement. You also want to, just show your instructions. So obviously if you do get an instruction, which, I mean, most of these instructions are now implied these days, because most of them, it's, with the constant change of contract documents, through portals and, document management servers, you're deeming instructions, through the updating of the construction drawings. So, more often than not, yeah, these are like implied instructions. You're having to read into them. I mean, really what you'd want there is that, that you've given a notice, or that you've told them that, we think this is an instruction, to carry out a variation, and we'd be looking for additional money, Obviously you want to give your notice, especially where you have condition precedents, goes without saying. That could, if you don't give those notices, then you may not be entitled to anything, so be very careful. You obviously want to show your quantities, show your calculations. I don't think anyone uses takeoff paper anymore. I think I just missed that era as well, but something akin to takeoff paper is quite, it's very helpful in the circumstances. You also want to show your rate build-ups, so you obviously include what's in the bill, or your contract sum analysis. Use your star rates, and you may have to bring in other information like invoices or day worksheets. I mean, try and avoid day worksheets as much as possible. Has been my experience. So yeah, so they're kind of just proving, just showing the build up to the rates that you've used. Obviously, you're going to be using drawings, marked up specifications, highlighting the changes. What was contract intent, and what did I actually do? So yeah, so there's these are just a matter of course. And again, just final point, just want to remind you, the records, very important. Even if you are entitled to variation, you still need the records to prove it. You still need to show the drop-off in productivity, which has resulted in the variation, or loss in expense. I mean, my preference is to go for variations as much as possible, because I just think you'd have more success there. But I mean, obviously, the same principle applies in loss and expense as well. So yeah, final, just really trying to emphasize the importance of records, and when you are looking for your variations. So yeah, and look, on that note, I'm going to conclude, just, recap, we've gone through the contract interpretation. You see how the courts deal with contractors where, contracts are silent. You generally don't get the benefit of the doubt, so be very careful with how you deal with specific points in the contract. Also, just when you're looking to, when you're looking at the categories, understand your right to reasonable objection, understand what happens if your work has been omitted and given to somebody else. Just know your rights there, because you can resist that. I mean, if they want to give it to somebody else, it's a breach of contract, you're going to be entitled to to loss of profit, or other costs associated with that. So bear it in mind. And then obviously, understand, how the courts deem to be a fair assessment, a fair allowance. It obviously includes overhead and profit, but, it does go a bit further. So be mindful of that when you're putting forward the variations, and hopefully you'll have more success with them, okay? So yeah, I think we've got a few questions, so we'll try and deal with those now. Is that right, Julie?
We have indeed got a few questions, Conor. They've been coming in thick and fast. Okay, so question 1. If a variation is to admit defined provisional sums in their entirety and amount to 50% of the contract sum, is the contractor entitled to loss of profit as they would have priced and programmed the project based on the provisional sums being included? And this substantial omission of works would mean that they would not get the profit they would have initially hoped.
Yeah, you know, it can happen. I mean, like provisional sums for 50% of the contract. I mean, that is significant. Um, Again, if you were signing up to that contract, you know, you won't be surprised to hear, you know, a solicitor saying that, you know, it all depends on what you say in the contract, because that can, you know, that can happen. But usually there will be a clause in the contract to say that, you know, if you don't go ahead with the provisional sums, then the contractor is not entitled. Um, he won't be entitled to recover that loss of overhead, loss of profit, loss of opportunity, and everything else that goes with it. So you want to be careful. Like the courts, but you know, that could be subjective. If you leave it silent, you're really running a risk that they can in fact do that. So you know, my advice is just deal with it expressly in the contract, especially if you're dealing with that level of provisional sums. It's very dangerous not to have clarity, because obviously if they don't go ahead, you will be at a loss. But if you're not entitled to it under the contract, then you won't be able to recover it. Okay.
Okay. If the contract remains silent on variations, will they be implied into the contract?
Yeah. So trying to think of some examples. I mean, they can be, but I mean, what, you know, you're now in a position um, where you're having to, you know, try and break down the, you know, the contract rates, or you're trying to point to something to show what you assumed that you would do. I mean, if you sometimes, you know, we see if you did submit a tender program, but the program did not find its way into the contract, for example, which does happen quite a lot now, because you know, most contracts just have a start and end date. But you know, the fact that you had a tender program, you know, as long as you don't have you know, an entire agreement clause, then you can, you know, you could rely on that to say, well, that did set out what our intention was as part of the contract. So again, you can see the importance of the, you know, of the contract, of the contract interpretation here, because dealing with, you know, you know, you have to go in explaining it, and you know, from experience, if you're trying to explain and, you know, basically build a case afterwards, you're on the back foot straight away. So you know, there's various ways of implying the variations afterwards, but I always say get it in there. You know, I know it's hard to see everything, but you can see how harsh that test is on contractors. And I hope that's a point that you took away from this. If you think it's a risk, always get it in the contract.
Okay, so advice there. Under the JCT contract, would you class the latest government COVID-19 restriction on construction works, i.e. the 2 metre distance between co-workers, welfare facilities, etc., as a variation?
Yeah, good question. On construction works. I mean, again, so there's two different points here. I mean, so you know, the 2 metre distance, you know, like I was like you know, I hope I made the point earlier, is that the 2 metre distancing, I mean, you'd want to be, I mean, you'd want to be providing records that has actually had an impact and reduced your, you know, reduced your productivity on site. And if you think that is the case, you know, you need to have records, you know, pre-COVID-19, and then also, you know, the outputs and records following the 2 metre distance working, because if you can show a drop off in productivity, then you know, then you'd be looking to recover that additional cost either through a variation or through loss and expense. I mean, this is going to be, you know, this is going to be a huge area for contractors to try and look for those costs, but you don't, you know, don't think that you get off the hook. You know, it's you're still going to have to prove it. If you can't prove it and you don't have the records to prove it, well, then I can't see you having success with that one. So be very careful. The larger welfare facilities, I mean, that comes down to, again, I go back to the contract. You know, who is it down to provide the welfare facilities? You know, a subcontractor where, you know, main contractor is, I mean, main contractor should be providing it, you know, for the duration of the contract. I mean, I think a main contractor should be going back to his employer and saying, look, obviously we're working through this difficult period. We're trying to keep the site going. Ultimately, they're keeping the site going for the benefit of the employer. So I mean, it's a conversation for a main contractor and employer to have, to see how you deal with these points, because the main contractors can only soak up so much here. So I think on that one, just bear in mind where you are. And like I hope everyone is with COVID, is that they're just being pragmatic and sensible with, the additional costs that are being incurred, and that no one's trying to profiteer on the back of this exercise, but be prepared to have those pragmatic and, sensible discussions. I really hope that is the case, because if not, it could have quite a negative impact for, for everyone in construction. So yeah, that's my advice on that one.
Okay. Omissions. What if part of the works have been omitted from the contract, and though those works will not be given to another contractor, they will be completed by the employer's staff in-house? Is this still classed as giving works to another contractor, and therefore a breach of contract?
It's going to be carried out in-house.
By the employer's in-house team or staff.
Yeah. But I mean, it depends on what it is, really. I mean, if you contracted, I mean, look at the bad bargain situation. If you contracted with a contractor to carry out work, I had this lately on a contract. It actually was in relation to some headings. And so basically the contractor agreed with the subcontractor to carry out. Now the contractor omitted the work and, did give it to another contractor. And, that is breach of contract. And in that case, the contractor, the subcontractor would be entitled to recover their loss of profit. I mean, I say it depends. I mean, if they just say in that same set of circumstances, say the employer started, the main contractor started their own kind of headings division, and got them to carry out the work, well, then I'd still see that as a breach of contract, because, you've kind of just brought in other people under a different guise, but the intent is still the same. And the intention has still been to deny the subcontractor the opportunity to carry out his subcontract works, which the courts say is what he's legally entitled to do. So, not surprising to hear a lawyer say, or a solicitor say, that it depends. But it does come back to what, in fact, the omission has actually been.
Okay. Someone's asked, could you clarify the definitions of category 1 and 2 variations? They're unaware of these in the JCT forms.
Yeah, so I mean, with JCT, if you look at your JCT contracts, you have clause, I'm thinking now of the JCT Design and Build 2016. So you go to JCT, you go to that contract. Clause 5.1.1, I call category 1. And category 1, I'm saying, is the addition, omission, or alteration of work. So I mean, they're like I think they're not the controversial areas of variations, because, if a construction drawing is issued and it's different to the contract drawing, then there's naturally going to be adds and omits to reflect the changed nature of the work. And that's that is a straightforward variation. So if you're looking at JCT contract 5.1.1, and what I call category 2 is clause 5.1.2, because that deals with the imposition of restrictions by the employer. So that's where he's asking you to carry out work, he's asking you to carry out work in line with your contract, but he's changed the conditions in which you're to carry it out. And this comes back to your, where he's changed the access to the site, where he's, impose different working space. So he might have, he might be loading up with other contractors on the site. He might have changed the working hours. He might say now that, the site is only open from 8 o'clock to 4 o'clock, when it said in the contract documents it was open from 8 o'clock to 6 o'clock, So that's like a classic category 2. where the additional restrictions you know, have been imposed on you, or, you know, that change sequence of the works, where he's trying to tell you to, if you've clarified what your sequence is in the contract and he tries to impose a sequence that is different to that, then that's another category 2 variation. I mean, it's not explained, that's how I explain it, but that's not how explained in JCT. But I just hope, you know, if you go back to JCT, you'll see those, that's how they've built up the clauses, and you'll see what I mean by those category 1 and 2. Okay.
Right, so basically what you're saying is they're your own div classifications, not a JCT definition.
Correct. Yeah, correct. That's my own interpretation of them, you know, and because I just think it's easier to I think it's easier to think of it that way, because, and then category 2, because people often ask about the reasonable right to rejection, to objection, that relates to only to category 2, that you don't want those added restrictions. Bring it up and deal with it at the time.
Okay. What is your view on CVIs being ignored by clients?
So this is where the client has asked you to carry out something verbally, and the contractor goes back and issues a confirmation of verbal instruction. I mean, yeah, I mean, I don't like that, because that's them kind of, you know, basically saying that they didn't tell you to do it. So yeah, I mean, if somebody was doing that with me, I mean, I would just say, sorry, but I won't be accepting any, you know, I won't be accepting any other verbal instructions. And if you want variations, you're going to have to write them to me. You know, so you just nip it in the bud early. I mean, that's the only practical advice I can provide there.
Okay.
Yeah.
If works are, it's just 2 more questions.
Yeah.
If works are omitted post-contract and it's lump sum with OHP declared, could a compromise be that the construction cost is omitted, but the GC can maintain their OHP level, which would ordinarily be based on a percentage of the contract sum?
Yeah, if work's omitted post-contract. Yeah, because if you think about it, the you know, if works are omitted, well then you know, obviously the contract, you know, the GC has the, you know, the opportunity to, you know, he's contracted to do that work, but, you know, what is his loss if that work is omitted? And it is his you know, his loss of overhead, you know, overhead and profit. So if he is being reimbursed for that, then I mean, I think that's a reasonable compromise, because actually that could actually be, you know, arguably a better position for the contractor, because he's realizing the benefit of carrying out the work without actually having to carry on the risk of actually doing it. So I think that's, you know, that's a very, you know, that's a very fair position to, you know, to have. And again, if that's going to happen, I just ought to say, try and deal with it in the contract if that is foreseeable during the course of the contract. Okay.
Okay. We've had another question in, so there's still 2 questions. Sorry, Conor.
No bother.
Would you advise a defined provisional sum should also include self-contractors' preliminaries cost?
Yeah, so defined provisional sums. So this is where, yeah, defined provisional sums, I think should, I mean, unless it's exceptional, I think, because defined provisional sum means that, you know, you've hit the categories. I mean, I'm thinking of the categories under SMM 7, you know, that the works are adequately defined, and, you know, you should be able to resource them adequately. And I think, and for me, that would include, you know, the subcontractors' prelims as well. So yeah, I think it's, you know, it's foreseeable that that the prelims should also be dealt with, because especially where the time has been included for the provisional sum in the program, well then it's, you know, it's reasonable that he's got to adequately resource that program, you know, which includes his prelims. So undefined, I'd say yes. Obviously with undefined, I mean, he'd cover an extent of it, but I wouldn't say the whole cost would be in there. But yeah, so certainly defined, I think it's reasonable for that it would include subcontractors' prelims. Yeah.
Okay. Just additional one just come in. Going back to CVIs, if they are ignored, can they be relied upon as contemporaneous evidence? In effect, no reply means they stand as an instruction.
Yeah. I mean, I would certainly try and do that. I mean, also you can follow up with an email. Follow up with an email, like just CVIs are helpful, but I'd follow up with an email just explaining, just set it out, just say, on the first of April, you asked me to carry out, you verbally instructed me to carry out, to dig a trial hole. It's like a classic one. You verbally asked me to dig a trial hole. I sent you a CVI. You haven't responded. Just letting you know that I'll be seeking recovery of that in the next valuation. And I just keep pressing the point while it's fresh in the minds. I mean, if they're like something like that, you should be dealing with it in the valuation, because if it's not agreed with, I mean, obviously they won't agree with it if you're not getting paid. But obviously, if you're not getting paid for it, then you're going to be taking on, you're going to have a negative, like that's going to impact cash flow. That's going to, potentially have a negative impact on the overall final account, which, as a vigilant subcontract or quantity surveyor, that is the position you absolutely want to avoid. So I mean, that's all I can really say about that. I mean, just deal with it at the time. Yeah, it helps the contemporaneous record, but I by all means send an email and just try and close it out in the follow-up evaluation is my has been my experience and my suggestion there.
Okay, and then finally, if a subcontractor is in delay completing an element of their work, you can instruct them to omit, say, a floor of the works and then instruct others to do. Are you in breach, and can they claim the loss of profits?
Yeah, good question. So the subcontractors in delay. I mean, if you read the contract, most contracts allowed, just say main contractor to, if he thinks that the subcontractor is going to be late, then the main contracts will, most of them say that, they reserve the right to employ additional resources to assist the subcontractor to make sure that they maintain production and maintain program. I mean, if it depends on, like, this kind of depends on how much the subcontractor is in delay. Sometimes you might be, I mean, you could actually be the case where if he's struggling so much, you could be doing him a favor by omitting the work, because he's thinking it's one less problem to deal with. But obviously, if you are intending on doing it, then you want to deal with the breach and can they claim loss of profit. I mean, they might try, but I mean, you want to deal with that at the time. Otherwise, your contract should say that you have the right to use additional labor. And the contract should also say that if you employ additional labor to construct that floor, and it actually costs you more than it would if the subcontractor built it, then you're entitled to recover that additional cost as well. So that's kind of the logic behind those clauses. So look, you may not necessarily omit it from the works, but you could top up the labor resource and just deduct it from the subcontractor that way as well. It kind of depends, again, it kind of depends on how late the subcontractor is, and what exactly what it is you're trying to omit there. Okay.
Okay. Well, that's great. Thank you. There's a lot of questions there, Conor. Thank you for your time in answering all of those.
No problem.
And as previously noted, if you guys have got any specifics you would like to speak to Conor about, don't hesitate to drop him an email. He'll happily answer them for you. We look forward to seeing you again soon. Thank you for your time, everybody, and stay safe, please.
Thanks everyone. Conor. Yeah. See ya.